your time. Thank you. Have a great day. Do I have anybody now on Shavlik and McGluther?
I'm here. Lori Shavlik.
Mr. Mitchell, are you there?
Yes, sir. I'm still here.
Okay, thank you. All right, Ms. Shavlik, I believe Mr. Mitchell had some preliminary objections to your motion. Did you receive that response?
Your Honor, I had Rion Oliver deliver to you through working copy my objection to his response. It wasn't timely, and there is no email agreement on file. And so anything in his response should not be considered because he mailed it on November 4th, which does not follow the court rules. And I put in, he didn't give me a response, and therefore my reply was late. And I didn't get his response until Saturday, which didn't leave me an opportunity to give me a reply. And so, Your Honor, I would ask that you strike his response and not consider it.
Mr. Mitchell?
I guess all response materials we were delivered to her post office box that we had before. Window PO Box 73 on the 4th. Remember, it was also emailed to her. It sounds like she received that document, whether or not she read it. Find out.
I did receive it in the mail on Saturday, but it is not timely. And I do not have an email agreement on file.
That's our position. I guess our position would be that we delivered it to her PO box as we had in previous matters with her, since she doesn't have a physical address for delivery.
The 3-day
Emailed it to her as
the 3-day rule still applies.
Well, Ms. Shavlik, the issue really in front of the court right now, and I think it's a preliminary issue, is why I wanted to address it with you, is whether or not we're even in court. Number one, if you properly got an order to show cause for your motion to vacate, which is required under Court Rule 60B. So I was wondering if you had reviewed court rules and whether or not, or not 60B, but 60E1. So whether you had gotten an order to show cause and whether that had been personally served on Mr. Mitchell's client, because that's what the court requires on these motions to vacate.
Your Honor, it's in docket number 15, and it's the notice of hearing signed by the commissioner.
But that's not an order to show cause, ma'am.
Raylene Oliver, the court assistant lady, she guided me through this, and she wrote all the documents and helped me, and she said this is the avenue and procedure to do this. So in docket 15, I have a court order signed by the commissioner for this hearing to take place today. There was nothing, he was personally served, and the service, I can give you the docket for his service as well, which was filed and on the record. His service of that document was October 27th, and it's stamped in docket 20 with his initials that he received it.
But it was a personal service for attorney's office.
Are you saying that I'm not allowed to serve his attorney?
What I'm saying is that orders to show cause under the court rule, especially on the motion to vacate, shall be served in the same manner as original process. So that requires personal service.
The court, I'm sorry, but Your Honor, this is a protective order, and the cops, the police, are supposed to serve for me. And Rion Oliver had taken care of that for me. So if the police didn't serve, then I would ask for a continuance, because he's supposed to be served by law enforcement.
Well, what I can do, Michelle,
Why are you laughing? This is not funny.
I'm not laughing now. I would appreciate it if you would have a respectful tone. I'm trying to sort through these issues here. One of the issues that I have is it looks like Nathan Joby served these documents on October 17th or October 27th. It says service to attorney's office.
He has attorney, Your Honor. His attorney is representing him. So maybe the police served him and they have a notice on file, but police didn't give me any return of service.
Who is the CNR? Is that his law firm? Is that yours? Cocktail Nichols Ryan, Mr. Mitchell? Is that what they're saying here?
Yes.
I believe so. We received documents at my office.
Okay. And I have two returns of services, Ms. Shavlik. One was, well, both are signed by Nathan Joby. Doesn't appear that that's to a police officer, and certainly indicates that they served the law firm and not Mr. McLeather personally, which is required by CR 60.
When they're represented by an attorney, the police are obligated to serve him, as they did the first time. So I would ask for a continuance so that he may be personally served by the law enforcement office.
And I'm a little confused because you're saying that you arranged for law enforcement service, but both of these declarations indicate that a Nathan Joby served.
Your Honor, his law office was served because there's a notice of appearance from a lawyer. So we provided that service for his lawyer. And also, Rian Oliver assisted me with trying to get the paperwork in order and what I needed to do to get this process done. Since I'm working against the commissioner and also the attorney, who's both arguing legal points against me, when it should be that I'm the petitioner and I should be getting the same assistance from getting the protective orders and the police officers to serve, just as they do for everyone else. So, Your Honor, I'm asking you to, if the police officers did not follow through with serving McLevern, I would ask that there be a continuance so that we could either find out why they didn't get served, or if they did get a proof of service and they just haven't filed it yet.
Mr. Mitchell?
Yeah, I don't know why there would be a need for a continuance. I guess if she wants to obtain the proper order to show cause and serve it properly, she could just renote her motion at a different date. The other issue that's a preliminary issue that was addressed in the response is that today's calendar, is my understanding, is the incorrect calendar for the local rules for a CR 60 motion to vacate. So what I wouldn't want to do would be get a continuance so she could serve it and then show up again and have it moved to judges' motions.
Ms. Shavlik, your response to that?
I'm working with the facilitator in the courts, and I'm going to continue working with the facilitator, and I'm going to provide her with the information that I've just been given. And so if there's something that she didn't do or the police didn't do, maybe they would have an opportunity to correct that.
Well, I just want to point out, and I think that it's always pointed out in the clerk's office and the facilitator's office, they do wonderful work in supporting not only the court, but the public in helping navigate some of these issues. But the facilitators are not attorneys, and they're not allowed to give advice. And so sometimes litigants may advice of an attorney regarding how to obtain a calendar date in order to show cause, and where that needs to be noted in Snohomish County. It is a local rule, Rule 7. And familiarize yourself with Court Rule 60 regarding obtaining an order to show cause and how you serve that. So I am going to strike today's hearing because I do believe that Mr. Mitchell may be correct that this is not on the correct calendar. Allow you the time to do that. That's without prejudice. They can come back and ask for that again. But at this point today, I don't have proper service, and we're not going to. Okay?
You're on.
Thank you.